right, good afternoon, everyone. Thank you so much for joining us today for this Vital Signs webinar on using state law to promote abortion access. Vital Signs is organized by the Health Law Program at the Drexel Klein School of Law, and we're really thrilled today to have two fantastic speakers. So the topic for today's session, since Dobbs was decided in 2022, state law has been a real focus of advocates and policymakers in abortion-supportive states who are looking for ways to limit some of the damage that's been done and will be done by the Supreme Court in overruling Roe, and to find new approaches to increasing access to abortion care. But state law was an important tool for protecting abortion rights and abortion access long before Dobbs. And we're going to start today's session with a discussion of a Pennsylvania case that was filed in 2019 that was designed to accomplish these goals. And then take a look at some more recent efforts since Dobbs to promote abortion access at the state level. We have two distinguished speakers to learn from today. I'll introduce them briefly. I realized I forgot to introduce myself. My name is Liz Kakura, and I'm an associate professor of law here at Drexel, and that is my role in which I'm moderating today's panel. So I'm going to introduce our speakers briefly. We'll hear from them, and then we'll save some time at the end for questions and answers. And so if you have questions at any point during the conversation, you can direct them to the hosts in the chat, and then I will be able to monitor that and pass them along to our speakers. So first up, we have Susan Fritchie, who is a co-director of the Women's Law Project, which is celebrating its 50th year as a Pennsylvania-based nonprofit dedicated to advancing the legal status of women, girls, and LGBTQ people. Based in Pittsburgh, Sue has worked at the Women's Law Project since 1992, and she represents the plaintiffs in Allegheny Reproductive Health Center versus Department of Human Services. Joining Sue, we have David S. Cohen, who is a professor of law here at Drexel's Klein School of Law, where he teaches constitutional law, reproductive rights and justice, and sex, gender, and the law. Prior to teaching, David was a staff attorney with the Women's Law Project, and he continues to serve as a consultant with them, including as one of the lawyers representing Pennsylvania's abortion clinics in the case we're discussing today. So diving right in, I'd love to start with Sue and ask you to tell us a little bit about what prompted you to bring this lawsuit and perhaps how it's similar to or different from efforts in other states or efforts at the federal level to secure reimbursement for abortion through the Medicaid program.
Thank you, Liz, and thank you for the chance to be on this program today. The Women's Law Project has represented Pennsylvania's reproductive health care providers for as long as it has been in operation, really. And part of what we do for the abortion providers in Pennsylvania is confer with them and find out what they need in terms of a legal framework to be able to provide the best quality care to everyone who needs it. And consistently throughout decades, what we have heard from our clients is that the #1 barrier to abortion care in Pennsylvania is the fact that we have no Medicaid coverage for abortion, except in extreme circumstances that are not very usable by most people. And those would be the well-known exceptions of pregnancies caused by rape, by incest, or pregnancies that are life-endangering. So we've always been trying to find a way to solve this problem, since this is the #1 worst barrier to abortion care. And back in 1985, we brought litigation to try to correct this problem. And at that time, the case was called Fisher, Joanne Fisher versus Department of Public Welfare. And it went up to the state Supreme Court. It was based on a state constitutional theory. It did not involve any federal claims whatsoever. And we lost spectacularly. We this was we lost in a way that was I found tremendously insulting and obtuse. Not only were our claims not granted, but the court truly did not understand what we were talking about. So the case was about the equality provisions of the Pennsylvania Constitution, including its Equal Rights Amendment. And our claim was that when you have a Medicaid program that funds all kinds of medical care, including virtually all the reproductive health care needs of men, but you carve out a very common need that women have, which is for abortion care. Very, very common, and extremely important for not only women's health, but our ability to control and direct our lives and our futures. When you do that carve out, there are gender equality consequences to it. And the Pennsylvania Supreme Court back in 1985 did not understand that, could not see it, and was extremely dismissive of those claims. It's not that surprising. Back in 1985, really the constitutional framework governing abortion restrictions was that of substantive due process and privacy. And gender equality was there as a theme, perhaps, but that was not the dominant way that these restrictions were analyzed. So years passed and the law changed. You started seeing, Justice Ruth Bader Ginsburg's dissent in Gonzalez versus Carhart, where she talked about how restrictions on abortion really are, yes, of course, about privacy, but really what they are about is about women's equal citizenship stature and ability to control their lives and make these important decisions. And then that became even more fleshed out in subsequent cases, including Whole Woman's Health. So a body of scholarship developed where many legal scholars wrote about how a more natural and accurate framework for abortion rights, other than privacy, would be an equality framework. So by the time we got to 2019, when we filed this litigation that we're talking about, Allegheny Reproductive Health Center versus Department of Human Services, the legal landscape really had changed, and legal doctrine around reproductive rights had shifted and shifted significantly. And even Planned Parenthood versus Casey in 1992 started talking about liberty more than privacy. So the law changed, and also the facts changed. So in the years since 1985 and today, we have come to learn very much more than we used to know about the impact of denying a person a wanted abortion. And most importantly, an extraordinary study called the Turnaway Study was done by the University of California in San Francisco that surveyed longitudinally what happened to people who were denied a wanted abortion and what happened to similarly situated people who were able to get that abortion. And the difference was very stark and common sense, I think, but here it was laid out empirically. So if you are denied a wanted abortion, you are likelier to be unemployed a year later. You are likelier to be less healthy. Your children are likelier to be not doing as well. You are poorer, you are sadder, you are sicker, you are in worse shape generally. So with that kind of empirical data, and with the shift in the law, we thought this is the number one problem that our providers are facing in Pennsylvania today, let's revisit Fisher. And that is what the Allegheny Reproductive Health Center case was about. We went back with the same two claims, the same Equal Rights Amendment claim and the same state equal protection claim, and we did it again. This time with a much more fully developed and vibrant legal structure behind us from all of the hard work that academics and legal strategists had done over those years, and with this new empirical evidence. David, do you want to add anything to that?
No, I'll just put something in the chat, which is a new report that was released just a couple weeks ago, sort of summarizing all the information we know and some new information we know about the barrier that the denial of Medicaid coverage poses for people around the country and the importance of states funding abortion under Medicaid. So I put that in the chat, so folks who are interested in that can check that out.
Thank you. So I think for supporters of abortion rights, sometimes reading the news these days can be a bleak undertaking. And it was lovely to get some good news here in Pennsylvania a few weeks ago. So can you talk to us a little bit, Sue, about how the decision that the Pennsylvania Supreme Court issued at the very end of January this year, how it's a win for reproductive rights?
Sure. So we actually have not yet won Medicaid coverage of abortion. So it is a win, but we are not done yet. The court that heard the case was not the full court. It was 5 justices. One of them, Justice Robson, recused himself, and just 3 weeks or so before the oral argument in the case, Chief Justice Max Baer passed away. So only 5 of the 7 justices of the state Supreme Court actually participated in the case. The issues, there were 4 major issues. The first threshold issue was, should you even be in this courtroom? So the Commonwealth of Pennsylvania disputed the abortion provider's standing to bring this litigation. And by a unanimous vote, all 5 justices found that they did have standing to assert the state constitutional rights of their patients. David argued that portion of, briefed and argued that portion of the case. And so I'm going to defer the finer questions on it to him. But we also won, and are so pleased that we won, on intervention. 2 groups of Republican state legislators intervened in the case at the Commonwealth Court level, and participated in briefing there and in briefing an argument before the Pennsylvania Supreme Court. And the Pennsylvania Supreme Court, in its January ruling, held that they did not have enough of an immediate interest that was special or different from that of any other person in Pennsylvania to be permitted intervener status. Instead, they were permitted to be heard through the voice of amici curiae. And so their filings were accepted as amicus briefs. And on the merits of the majority opinion, it was a 3-2 ruling. Justice Christine Donahue ruled that restrictions on abortion can be seen as a form of sex discrimination and are thus presumptively unconstitutional under our state Equal Rights Amendment. And this is a huge sea change in the law that recognizes the importance of reproductive liberty to women's equality. It really connects the dots. That decision overruled Fisher. And the significance of that, I think, is that, the Equal Rights Amendment is pretty absolute. It just says there shall be no gender-based classifications. in the law. You can't award benefits or impose burdens on people based on their sex. And yet, the Fisher Court back in 1985, in rejecting our original challenge to the Medicaid abortion coverage ban, found it sort of read into the plain language of the Equal Rights Amendment a gigantic exception. And that exception was whenever there is a legislative classification that turns on a unique physical characteristic that is unique to one sex, then it's okay to treat the sexes differently then, because you're talking apples and oranges. So anyone who has paid any attention to the history of the struggle for gender equality in this country knows that it is reproductive capacity that is always invoked as the reason why women can't be lawyers, why women can't serve on juries, why women can't be bartenders. All of these discriminatory practices are founded on the belief that it is women's true calling and only real purpose in life is to reproduce. And so anything that could interfere with that or coarsen, this gentle, feminine person would be not something that could be allowed. And so many of the restrictions on women's liberty and women's opportunity were justified based on our reproductive capacity. So what the Fisher Court did in carving out this whole exception from the general rule of gender equality, anytime something dealt with pregnancy, with lactation, with reproductive health care, it really weakened and eviscerated the Equal Rights Amendment. And when you look at cases that were brought under the Equal Rights Amendment, it was so vibrant in between the adoption of that amendment in 1971 up until Fisher. And then when Fisher happened, that was kind of the end of the development of the Equal Rights Amendment. And what this case did in January was overruled Fisher. So this is really, just, I think, a huge development in Pennsylvania state constitutional law, and a really good one.
So maybe that's a great place to turn to David and talk a little bit in terms of this litigation. What happens next, right? We know it's not over. Why is it going back to the Commonwealth Court? What remains for the court to consider? What are you going to be arguing to the court when you go back and tackle the next stage of this litigation?
So the decision from the Supreme Court gave us a standard to apply to the Medicaid coverage ban, but it didn't analyze how that standard actually applies yet. So basically it said that the ban on sex discrimination in the state's Equal Rights Amendment is not an absolute ban. It didn't go so far as to say all sex discrimination is unconstitutional. And we didn't ask them to say that because there are circumstances, for example, making up for past discrimination against people who are pregnant, for instance, that we would want them to be able to do that, or special maternity care programs. So they did not adopt an absolute ban on sex discrimination, but they did say that instances of sex discrimination are presumptively unconstitutional, and the burden is now on the state to show that there is a compelling state interest and that there is no less intrusive method available to accomplish the state's policy. So that's what we have to decide. That's what the lower courts have to now decide. So in Pennsylvania, when you're suing the state, the Commonwealth Court, which is normally an appellate court, is actually the trial court. There's no intermediate appellate court. And so the case is remanded to the Commonwealth Court to, in the first instance, apply this standard. But this standard, like I said, we don't have to prove the law is unconstitutional at this point. Now the state has to prove that it is constitutional because the burden is on the state of Pennsylvania, not on the challengers. And the burden is probably one, when you think of rational basis review, intermediate scrutiny, strict scrutiny in the law, the court doesn't use the term strict scrutiny, but it uses terminology that is usually associated with it. It is the highest level of review short of an absolute bar. And that is the hurdle the state now has. One of the concurring opinions from Justice Wecht said the state is in an unenviable position because this burden is so high. So that's what has to happen. Technically, the case has actually been remanded. We have not been assigned a judge yet. We are awaiting that. And because these were preliminary objections that were overruled, it is now upon the state to answer our complaint 5 years later.
So we're going to expect a final resolution here sometime, what, in the next century?
We are hoping not, right?
Oh, I hope it doesn't take.
The twists and turns of this case that happened since 2019, it does not seem like they should be replicated. And the standing issue is gone, the intervention issue is gone. Now we just get right to the merits of the case with this really difficult standard for the state.
Now, one thing I'd like to add, one thing we did not win. We asked the court to recognize explicitly what we think is implicit in the Declaration of Rights and in the Constitution, which is that abortion is a fundamental right under the Pennsylvania Constitution. And Justice Donahue and Justice Wecht agree with that and said as much. Justice Doherty, the third justice in our majority, was not willing to go there yet, but did call it incredibly insightful. And we will see whether that bears fruit in the next case.
So thank you for adding that. In terms of this issue of time, right? And I mean, litigation takes a lot of time in general, and then things happen politically or in the courts to also delay, right? You had some threshold issues that also needed to be briefed. Given that it's been 5 years, right, and a lot has happened in the abortion access landscape during that time, unconnected to your litigation, although impactful in so many ways. I was wondering, David, if you could talk a little bit about whether or how Dobbs changed anything about your litigation strategy or the significance of this case. Sort of, we're talking about a state case brought under a state constitution. This is a state law, right? Everything about this is state law, but it's not entirely disconnected from all of these other things that are happening in abortion law at the federal level. So could you talk a little bit about the role of Dobbs, in the work that you're doing in this case in particular?
So as a technical matter, Dobbs has no influence whatsoever on this case, right? Because our case was completely under state constitutional law, and we did not raise any claim whatsoever. And we were very careful about this that could possibly have gotten us into federal court, right? Or even appealed to the US Supreme Court. We did not want to raise any issue that somehow could be even connected to federal law that could get us there, because even though we filed this in 2019, we certainly were well aware of the headwinds in the US Supreme Court when it came to abortion, and we did not want to risk anything getting into federal court in the US Supreme Court. So we kept it purely state constitutional focused. And of course, while the case was, we had just finished briefing the case at the Pennsylvania Supreme Court when Dobbs was decided. So the spring of 2022 is when we finished briefing our case. Dobbs was decided June of 2022. I forget, Sue, do you remember, did this court reach out to ask us to brief about Dobbs, or did we ask to brief something about Dobbs?
Oh, we did.
Yeah, so we asked the court just to file a short brief to say basically the fact that Dobbs overturned Roe does not change anything with respect to the issues before them. And actually, we were able to put in some material that actually we think helped a little, because the governor at the time, Governor Wolf, issued some statements post-Dobbs indicating that he believed this was an important right to be protected, and we were able to put that in our brief. But at oral argument, Dobbs didn't really come up, and the decision itself obviously doesn't rely on Dobbs, but I think it's a backdrop, right? I think these justices are well aware that with the removal of federal protection for the right to abortion under this federal constitution, that it's even more important that Pennsylvania consider to protect abortion rights in some way. So here, with the majority just saying that it's sex discrimination under the ERA or presumptively unconstitutional, again, separate from the issue in Dobbs, but I do think that that was part of the backdrop. And then there was a very lengthy concurrence from Justice Wecht, where he took on Dobbs head on. Again, not necessary to deciding the state constitutional issues, but he wrote a lengthy, academic, thoughtful, well-researched opinion, really taking Justice Alito to town for his history and his reasoning in Dobbs. Notably, he does not take him to town for overruling precedent, because that's what happens in the Fisher case. In our case, we overturned Fisher. So we were never of the position that the problem with Dobbs was just that it overturned precedent. We were of the position that Dobbs was wrong as a matter of substance, because we were trying to overturn precedent of our own, right? Overturning precedent is not inherently problematic. We were seeking to do that, and Justice Wecht was a part of it, but he attacked Dobbs for the substance of what it said. And it's a really interesting read that I strongly encourage people to look at if they're interested. He cites all sorts of legal academics and the research they've been doing about abortion rights and equality. It's a very eloquent decision in response. It's really a direct response to Justice Alito.
I also think that the Dobbs backdrop found its way into the majority opinion of Justice Donahue, because she went to every length possible not to invoke federal law, not to link the interpretation of the Pennsylvania Constitution to anything in the federal Constitution, not even using the term strict scrutiny, avoiding the use of that term. She shut the door as hard as you can shut a door on Pennsylvania proceeding down the history and tradition path of analysis by saying that our Article I rights are inherent rights. They are not subject to the history and tradition analysis used by the Dobbs court. They are inherent. So yeah, I think every piece of that majority opinion was geared towards not following the path of the Dobbs court.
It's a very interesting dynamic there in terms of thinking about the relationship to what's going on in federal courts and at the federal level. In terms of the decision overruling Fisher itself, so you talked about how significant that this is as a moment in equal rights jurisprudence, and that the Fisher had sort of forestalled further development in this area. So I was wondering if you could talk a little bit about how if we think about this as a reinvigorated ERA, how that might affect other rights in the Commonwealth.
Well, we have seen recently how some states have taken to burdening the right to fertility treatment. When you look at Alabama, that is a reproductive health issue that could be protected by the ERA, I believe. Contraceptive rights, there's very little question that certain kinds of contraception, in particular IUDs and some hormonal methods, are in the crosshairs of the anti-abortion movement. It is not only an anti-abortion movement, it is an anti-contraception movement as well. But that would be protected. Pregnancy, lactation, could be protected. There's even just an interesting piece where this might be one of the first Pennsylvania state constitutional rulings to acknowledge that men can become pregnant and experience childbirth. So the recognition of trans people in this ruling about sex discrimination envisions a concept of equality that embraces all genders, and is a suggestion that this binary model of sex equality, sorry, that the binary model that we have seen historically can be reshaped to include trans and gender nonconforming people as well within its protection.
You talked a little bit about kind of breaking down the different opinions here, and there's a lot of pages that the court issued. And one notable part here was that although he declined to join his colleagues, right, in finding a right to abortion under the state constitution, that Justice Dougherty called Justice Donohue's analysis on this point incredibly insightful. It's such an interesting little aside there. What do you make of this line? How do you think we should be understanding this?
Oh, I read it as an invitation. You know, it is very, very difficult to provide abortion care in Pennsylvania. Not many years ago, Congress subpoenaed from all of the state health departments all of their statutes, regulations, guidances, and protocols that they required of abortion providers. I guess in a way to show that abortion is underregulated. Pennsylvania produced 1,237 pages of statutes, criminal statutes, regulations, restrictions. So it is really hard to provide abortion care here now. And with this ruling, which states that restrictions on abortion are a form of sex discrimination and presumptively unconstitutional, unless the state can show a compelling state interest in that the restriction is a necessary and narrowly tailored way of advancing that. I think some abortion restrictions are going to be challengeable and should be.
Before we turn to talking a little bit about developments outside of Pennsylvania and other parts of the country, we have a question in the chat that would, I think, be great to address here about how the Pennsylvania approach to the ERA might impact other states like Texas that appear to be ignoring their ERAs. So if either of you have thoughts about, from the analysis front or thoughts about what advocates could be doing or how they should be thinking about this to try to make progress on these issues in other states and states like Texas, we'd love to hear them.
Well, before this decision, there were only a handful of state Supreme Courts that had addressed their state ERA and our specific issue, Medicaid coverage for abortion. And so New Mexico is one of them. And the Pennsylvania Supreme Court decision from January relies very heavily on a New Mexico decision from the mid-1990s that also found that the state ERA did not allow the state to ban Medicaid coverage. And that was really, in our mind, a really great decision. We relied on it heavily in our briefing, and the Pennsylvania Supreme Court did as well. The Texas Supreme Court was another case. There's another court that had previously decided this issue, and the Texas Supreme Court had really just followed the Fisher Court. It cited Fisher, the 1985 case from Pennsylvania, and followed it in saying that their state ERA does not mean that the Medicaid coverage ban was unconstitutional. And they had a very cramped analysis, just like the previous analysis from the Pennsylvania Supreme Court. Certainly, we would hope that the Texas Supreme Court would look at what the Pennsylvania court has done and what the New Mexico Supreme Court did previously and say that it has seen the light And we now understand that the best interpretation of the ERA is that adopted by Justice Donahue and the New Mexico Supreme Court. But we're certainly under no illusions that the Texas justices would agree with that, given, our understanding is that they are all very conservative justices. However, of course, we will see what they say. There's a case pending in the Texas Supreme Court right now around emergency exceptions for the state's abortion ban. And we'll see what they do in this regard. It's, I think the smart money is on them right now, not yet adopting the interpretation from the Pennsylvania court. But it's certainly, we would hope that this is something that has gives guidance to other states with ERAs. I think the numbers in the mid-20s with I don't know the exact number of states that have their own equal rights amendments, but it's in the mid-20s. And so it's certainly ripe for other states to learn from what this court did.
Texas has a weird Medicaid statute though, right? So Texas has a statute that neutrally, without any reference to abortion, will not provide Medicaid coverage for anything for which there isn't federal financial participation. So they're a little bit, it could possibly be a little bit easier for them to make out a case that they are not discriminating based on sex because of that neutral principle. But I agree. I am not holding out a lot of hope that they will change their position.
I want to make sure we have time to talk about some developments elsewhere around the country where advocates and policymakers are using state law to promote abortion access. So, David, if you could talk a little bit about the types of advocacy that we've seen at the state level to either counteract the impact of Dobbs or just to continue the work of trying to expand access to abortion. What are we seeing in the states?
Just been a ton of activity post Dobbs in various states. So there's been lawsuits that have been filed post Dobbs, and I just mentioned one in the Texas courts about emergency healthcare during abortion, during pregnancy where someone needs an abortion. We've seen challenges under other states' constitutions. And so the litigation in state courts, that's hasn't been a surprise. And that's an ongoing part of what's happening. I think the biggest surprise post Dobbs has been the pro-choice side has run the table on a series of ballot initiatives in a wide variety of states. So we saw this 6 weeks after Dobbs in Kansas, of all places, right? Kansas, deep red state in terms of presidential election, a history of the worst anti-abortion violence in the country. And Kansas had a great decision in 2019 from their state Supreme Court recognizing a right to abortion under their state constitution. And so there was a referendum put to the people in an off-cycle election in the primary election, August of 2022. It's not exactly election season for most people. And there was a ballot question of whether that decision basically should be overruled and whether there should be a new rule that there is no protected right in Kansas to abortion. And the polling leading up to that ballot initiative showed that it was likely going to, the state Supreme Court decision was likely going to be overturned. And yet on election day, the pro-choice side came out in massive numbers and shocked everyone by having a double-digit victory at the polls, right? The polls ahead of time showed that they were going to lose by a few percentage points. In the actual election, they won by double digits. And that just kicked off a string of successes at the ballot box on single issue ballot initiatives. So since then, we have seen California and Vermont, obviously very liberal states, not unexpected. Michigan, we've seen a pro-choice win there. Obviously, that's a more middle of the road state. And we've also seen pro-choice wins in Kentucky, Ohio, and Montana. And not all of those are for complete legalization. Ohio was. Kentucky was to beat back, sort of making it even more difficult to get an abortion. And Montana was something a little a sort of a side issue. But in all 7 of those elections where there was a single issue ballot initiative presented to the people around abortion, the pro-choice side won. And given that some of those states are some of our most conservative states in the country, namely Kentucky, Montana, Kansas, when you're talking about presidential politics, there is now a big movement to put on the ballot for November 2024 ballot initiatives in many different states. And I think the estimate I've seen is roughly 12 states may have ballot initiatives that are single issue abortion ballot initiatives to see if the streak continues. And to see if that has any impact as well on any other elections that during this cycle too. So the ballot initiatives have been a huge, huge success for the pro-choice side. Couple other things. Some states have states where abortion remains legal. There are many state legislators that have looked at their abortion laws and said, oh, actually, we have some laws on the books that make abortion difficult to obtain. Maybe it's a requirement that only doctors provide abortion, even though it's within the skill set and professional qualifications of advanced practice clinicians, like nurses, like physician's assistants, like certified midwives. And so they've gotten rid of restrictions like that in many different states. So they've expanded access in states where abortion remains legal. Many of these states could have just said after Dobbs, abortion's legal here. We're not going to be Alabama. We're not going to be Tennessee and ban abortion. Abortion remains legal here. Everything's great. But they've actually looked at their laws and said, yes, it's legal, but how can we make it more accessible for people? Something we've been asking them to, pro-choice advocates have been asking them to do for decades, but Dobbs has really given them the impetus to do that. 2 other things quickly, and then I'll stop. States have expended a lot of money to support abortion access. So California, New York, Oregon, Maryland, in particular, Illinois have spent millions, if not tens of millions of dollars in some of those states to support the abortion providers in those states, to support abortion training, and to support abortion travelers, because we know a lot of people are traveling across state lines to states where abortion remains legal and supporting them with their needs. So states have expended a lot of money. And then finally, 17 states and the District of Columbia have passed what are called shield laws. What these laws do is protect the abortion providers in those states who provide care for patients coming from other states, so that if that patient goes back home, say to Tennessee, and their ex-boyfriend or their parent or a neighbor or the local prosecutor wants to take legal action against them for getting an abortion, and they try to rope in the abortion provider in one of these states, or anyone who assisted, so an abortion fund, that those people are protected from out-of-state legal action, including extradition, because of these shield laws. And so these are an innovative new law that came about first in Connecticut in May of 2022. And now we have 17 states and the District of Columbia that have some form of an interstate shield law.
David, you modestly did not note that you and a couple of other Pennsylvania academics were the originators of that concept.
Yeah, we did. We worked on with Rachel Rebusche, the dean at Temple, and Greer Donnelly, a law professor at Pitt. We worked on the first one in Connecticut and many of the others that have passed.
So before we get to questions, I would like to talk just a little bit more about shield laws here, particularly because you have such deep expertise in their genesis and sort of the work that they're doing. David, could you talk a little bit about the sort of thought process of what, sort of what's different about these laws? Why was this attractive to a state like Connecticut, when they were sort of trying to think about what they could do themselves as a blue state to try to protect abortion access and protect providers? What were those conversations like, or what is different about this particular sort of moment in legislating around abortion access?
So I think the basic idea of the shield laws, so let's take Connecticut as the pro-choice state and Tennessee as the state where abortion is banned, right? Connecticut can't do anything to change the fact that Tennessee sees abortion provision as criminal, or that it allows for, say, a wrongful death lawsuit around abortion. Connecticut can't change Tennessee law. But what Connecticut can say is we are not going to participate beyond what's required by the Constitution in anything that Tennessee tries to do involving our providers. And so if, say, there's a student who's at a Tennessee individual who goes to school, college in Connecticut, and they get an abortion, they go back home, and like I said, their parent tries to take some action against the abortion provider because there's wrongful death of my grandchild, for instance. That's what they say. Connecticut's courts, Connecticut's police, Connecticut's executive branch are not going to participate in that Tennessee action. And so that's the basic idea of these shield laws. It's basically just a non-cooperation with what we see as the policy that your policy should not reach into our states. There are 6 states, Massachusetts, Vermont, New York, Washington, Colorado, and California, that have gone one step further. And what those 6 states have done with their shield laws is say that we will not have any repercussions for providers within our state who mail pills, abortion pills, into states where abortion is banned. So if you are, say, a New York abortion provider, and you have your license in New York, and you are physically located in New York, and you have a patient who calls you from Tennessee, and you say, okay, well, you want to have an abortion, you are medically, qualified to, or you are a candidate to have abortion pills, I will mail you those pills. Tennessee will see that as a crime. But New York is saying we are not going to participate if Tennessee tries to prosecute that provider. Now, everyone says, well, what about extradition? You have to extradite people. Well, you only have to extradite under the Constitution if the person who's accused of the crime was physically located in the state at the time of the crime. And because we're talking telehealth, there's no such thing as constructive presence under extradition law. This has been settled for a long time. So the shield laws from those 6 states have enabled doctors and other advanced practice clinicians practicing within the scope of their practice under state law. It has allowed the providers in those states to begin mailing abortion pills to people in those states where there's abortion bans, and they're able to get care. And the most recent numbers show 6,000 or 7,000 packets of abortion pills per month being mailed into states with abortion bans. So that's people who are in states where abortion is banned, who would otherwise have to physically leave the state to get care, are able to have an abortion in the comfort of their own home or any other space they feel comfortable in. This has been a huge way that access has continued post-Dobbs, despite abortion bans. And there was a long New York Times article about these providers just a week ago that I'll also put in the chat.
Thanks. And just to clarify, when you're talking about that number of packets that are mailed into states, you mean as a result of a telehealth appointment with a doctor in a different state where abortion is legal?
Correct. So these are people providing under their state shield laws to states where abortion is banned.
Great, thank you. All right, I think now's the time when it would be great to turn to a few questions that we've had from our attendees. So starting first with a question about the Hyde Amendment and whether there has been any effort to challenge the Hyde Amendment since its genesis. David, could you talk a little bit about challenges to Hyde?
Sure. So Hyde was passed in 1976, and it was immediately challenged, right? This has been in the crosshairs of the pro-choice movement from the moment it was enacted. And so there were 2 cases decided in the United States Supreme Court in the late 1970s that said that under Roe v. Wade, the Hyde Amendment was constitutional under the theory that Roe v. Wade was about the liberty to choose, and people can still choose under the Hyde Amendment. They just don't have the means to carry out their choosing. It's just like how if I choose to create a newspaper that's, the rival of the New York Times, I can choose to do that. I don't have the means to do that, and the government doesn't have to provide me with the means to do that. That was the thinking behind these cases. And so those two, so the Hyde Amendment was challenged immediately in federal court and lost. But then all around the country, there were challenges in state courts as well, including the Fisher case, right? So the Fisher case was one of many challenges, I'd say dozens of challenges around the country in different states, trying to use state constitutional provisions to strike down the state part of the Hyde Amendment. And a lot of those were successful. Some of those were not, like in Pennsylvania, but there are now 17 states that provide Medicaid coverage for abortion under either a court decision or lobbying efforts in state legislature or administrative apparatus. So that's been an ongoing process. In Congress, Hyde was never really, it was challenged, but there was an organized campaign about 15 years ago that really started focusing on getting rid of Hyde in Congress. And it has passed the House, I think, once to repeal Hyde, but it has never gotten the majorities in both houses of Congress. And so technically Hyde is an annual rider to the budget, and it gets passed every year as part of the federal budget. And there are lots of people working on trying to remove that, but so far it's been unsuccessful.
One thing I want to just add to that is that one of the truly wonderful aspects of Justice Weck's concurring opinion in the Allegheny Reproductive Health Center case is that he uses, several pages to talk about how just because the Dobbs court held that there is no fundamental due process right to abortion in the US Constitution should not discourage advocates for reproductive rights from trying other theories. And it is just pure dicta, of course, but such refreshing and such energizing ideas, talking about other approaches that could call on different constitutional provisions and different frameworks in order to bring new litigation to challenge some of the restrictions nationally. So I really encourage everybody to take a look at the majority opinion and also at Justice Weck's really just creative and interesting concurrence.
And in that spirit of thinking about trying different approaches, right? Trying new arguments or returning to arguments that have failed, but maybe, right, the facts have changed and we know more and we can say different things about how the law should be applied. We have a question from one of our participants about risks related to, maybe trying new things and making these arguments, particularly kind of taking us back to Texas and the previous conversation about the ERA there. If there's a concern that challenging state abortion restrictions, say under equal protection, could create more harmful precedents in a state like Texas. And I suspect that, that's perhaps best left to, experts in Texas state law, right? Advocates who are there on the ground and are most familiar. But if either of you have thoughts about, sort of balancing the need to try new arguments and take risks with concern about, creating harmful precedents that will, then take that much more work and more time to try to undo or counteract.
This is a problem for any social change litigator, right? You're always faced with having to really guess what your chances are of pushing the law in the right direction and what the risks are that you might be setting us back. In this case, we did not really have much of a problem with that because we already had virtually no coverage of abortion, and the state equal rights amendment had already been interpreted in the worst possible way. The only real worry that I think we had was that the case could provoke a state constitutional amendment to remove the Equal Rights Amendment from the state constitution, or to implant an anti-abortion amendment into the Constitution. So there was one that was proposed, that passed once, but it has not been reintroduced in our state legislature. And I think that may be a reflection of how unpopular these abortion bans are nationally, even in states where you don't expect them to be.
Question about this particular litigation here, given the change in the burden now for the Commonwealth, the questioner asks whether Pennsylvania could settle by just agreeing to change the policy rather than going forward with trying to meet this heightened standard.
So without saying too much about our litigation strategy and thoughts about it, certainly our goal is to have an outcome of this case that will survive changes in administration. We don't want any success we may have in this case to be limited to when we have a good governor or a governor who supports abortion rights. So with that in mind, we're exploring all possibilities for what to do next, obviously in conjunction or in reaction to and discussion with the lawyers for the other side.
Another question about shield laws and whether these are similar to trans shield laws. Maybe another way to say that is, some of these states have also changed the rules that they have around providers who are performing gender affirming care. What's the connection between these different types of provisions under state law?
Yeah, this has been a really wonderful part of sort of the advocacy post-Dobbs, is that there have been now 9 or 10 states that have defined the protected healthcare activity covered by their shield law as including both reproductive health care and gender affirming care. The advocates are working closely together on these issues, seeing the combination of seeing how the overlap in sort of bodily autonomy, individual decision-making, privacy, and also just the attacks from the same people on people's ability to control their future and their identity, that abortion bans and gender affirming care bans have in common. And so the groups have worked together mostly. I've worked very closely with GLAD, who's working on a lot of these telehealth bills with respect to gender affirming care. We've seen a lot of movement. We've seen legislatures motivated by Dobbs, motivated by the attacks on gender affirming care, to combine them into the same law, and been very successful so far in them doing that.
I think, unfortunately, we are out of time for today. This brings us to 1:30. I want to say a big thank you to both David and Sue for joining us and taking the time to share your expertise and provide these important updates. I will say, just on behalf of myself and not anybody else here, I think it's so important to be taking a close look at the role of state law in ensuring abortion access, and in particular, and for any law students who are listening to this, right? We spend a lot of time in law school reading and studying federal court cases and thinking about what the federal courts are doing, and can sometimes miss the importance of state courts and state judges many of whom are elected, right? Including here in Pennsylvania, where we have judges who will be up facing retention votes in upcoming election cycles. And so that's a really important place to be paying attention for folks who are interested in how the law addresses this important aspect of healthcare. So thank you both, David and Sue. Thank you all for joining us today, and have a wonderful afternoon.